Back. Like I said, I wanted to break it up because it was already getting to a little long point. So this is part two of the notes. If you didn't watch part one, go back. Anyway, so let's talk about. I said I was going to talk about the role of legislature, the judiciary branch, and the executive branch. We're going to talk about those kind of briefly. Talk a little bit more in depth about some of those things. These are all part of chapter one. So obviously, I'm not reading the textbook to you word for word because you can read the book. But I'm kind of hitting the high points and trying to make sure that you have a well rounded understanding of the basics of what is criminal justice. So, the role of the legislature, if you're not familiar, these were the three branches of government: the judicial branch, the legislation, and the executive branch. So, the legislative, this is the lawmaking branch of government. So, the big, most important, I wouldn't say the most important, but the most well known one is Congress. So, this is the one that determines what is a crime and what is a fair punishment for each crime. The other job that they have is they provide funding for different agencies. So Congress is the one that determines Erie Police gets this much money. Well, they determine how much Pennsylvania gets, and then how much each of those gets. So it is important to know that specifically the legislature, the Congress, and that kind of stuff, it is a whole bunch of rules. We already kind of talked about the whole thing of crime is you're breaking the law, you're breaking the rules of society, and so the whole point of having a legislature is to make sure that these things are in order. So official versions of laws are organized by subject. These are called codes. The whole reason I bring it up is because you might have heard of the penal code before. That's the criminal code. That's all the collection of statutes and laws and sub-laws that define what crime is. And so that's kind of why I at least wanted to touch on that briefly. But we're going to talk about the judiciary system. Specifically, that's the hierarchy within the court system. And so the most famous, popular, well-known one is the Supreme Court. And this is where, Supreme Court justices are placed by presidents. This is not an elected position. So that's just important to note. But it is the hierarchy. There are different kinds of courts in the judiciary system because it is the court system as a whole. But like I said, the Supreme Court's the higher one and the one that most people are familiar with. And so, again, I like criminals in court stuff. So there are two types of courts. There's trial courts, trial courts and appellate courts. I don't really think I need to spell trial. I totally messed it up too the moment I spoke. So I'm embarrassed. IAL. So there's trial courts and then there's appellate. And if you know context clues and you can look at a word and say, hey, that looks like this word, you probably get where this is. Just give me a second to finish writing. Okay. So the trial courts, these are the ones where we're most familiar with, simply because they're the ones that are usually the ones that movies and TV like to focus on. The trial courts are the ones that they're looking for guilt for a person charged and trying to get the sentencing for that crime for that person. So the trial courts are the standard courts you see all over the place. They're the Erie County Courthouse. That is a trial court. But the appellate court, if you notice, appeal is part of that. This is a court designed, it does not conduct criminal courts. So if you bring a criminal course or civil case, it is not often first at an appellate court. It's always at a trial court. The appellate court is really, they hear complaints raised by people unsatisfied by the trial court or other criminal justice aspects and outcomes. This is where, again, not getting into controversy, but the entirety of the Amber Heard Johnny Depp trial. That's another thing that we'll probably talk about briefly in this class. just to talk about how the court system works. But that was in a trial court, and Amber Heard was unsatisfied with the outcome, and so she appealed the courts. That is part of that process. I'm oversimplifying how it works, but that is a real world example that if you've been paying attention to what's going on in celebrity world, that is what we're talking about. The appellate court is you want to appeal some kind of decision or law or choice or whatever, and so that's the court that listens to it. Again, trial court is the more common and the more widespread for the everyday person. And so this is something that's kind of interesting and important to note, simply because, again, Hollywood has taught us the wrong thing. So most criminal defendants who don't have their charges dropped prior to being formally charged end up pleading guilty. And this is usually coming from plea bargains. And plea bargains is just a fancy way of saying that the prosecution offers the defendant some kind of lesser sentencing or lesser punishment, payment, whatever, as long as they say that they did, in fact, commit the crime. Unfortunately, the reality of the world is not every case is a let's take it in front of the judge and the jury and let's have this whole big, long, drawn-out court proceeding. That is not the norm. They do happen, but it's important to note that most criminal cases do not result in a trial by jury. They're usually solved before that. So it's just important to note that no, they do not all result in a trial by jury. And so, as I said, the appellate courts have judicial review. They review a law made by legislature or a decision made by a court and determine if the constitutional standards are met or violated. If they are violated, obviously that would make the entire thing void, and that would lead to a different result. So they also, and this is important, the appellate court also reviews actions of government employees, so police misconduct, government official, all that stuff that is dealt usually with an appellate court. And so now we get to the third branch, the executive branch. This is the one that, we tend to remember. This is the president, the governors, the mayors. This is all the other people that aren't in, the court system. So the whole point of the executive branch is that it appoints positions of power, which is another way of saying administration. So they're the ones that decide, okay, well, the constituents voted for this person for sheriff, so that person is going to be sheriff. This is the governor. This decision, I am going to appoint this deputy. I'm going to appoint this individual. They are the people, the executive branch puts people in positions of power. And so they are the ones that set the criminal justice agendas and can galvanize public opinion. The best example I can give of this, I know it's older than a good portion of my students, but the war on drugs from the late 70s and early 80s, this is a great example. The executive branch, we had both Reagan and Nixon in power, and the whole war on drugs. We know historically, looking back, that it really was a scapegoat to kind of avoid some other things, but they put policies in place. There's a reason that the DARE program came into existence. There's a reason that there are still individuals in prison, mostly Black and Latino, who are in there because of marijuana possession. This is all related to that. So there is historical things you can look at to be like, oh, that's what he's talking about. And so obviously with this kind of appointing power and determining which way things go, this is the use and misuse of discretion, not just for officers, but for individuals who make those decisions. Because the power of the individual to make decisions based on their personal judgments. And so this is how, again, not getting political, but this is why there's always a discussion of Republican and Democrat, because of our two-party system. There's always, they're making judgments based off of this belief. Is it equal and fair? Maybe not. And so this is also one of those things that has led to the rise of the Black Lives Matter movement. I do want to emphasize, just for anyone who is not completely understanding of it, the Black Lives Matter movement started way before 2020 and way before George Floyd. It actually started back in about 2014, 2015. So it has been around a lot longer than people realize, but it did get more recognition after the George Floyd incident. So just want to mention that the use and misuse of discretion has led to more acknowledgement of this, of the Black Lives Matter movement, as well as the Blue Lives Matter movement and the ACAB. If you don't know what ACAB stands for, it is a kind of a pseudo battle cry of all cops are bastards. It's a whole thing. Again, we're not getting into a discussion on whether it's right or wrong, but it's important to understand that these are the kind of, on the person level, on the you and me level, this is the results of when people use and misuse discretion to decide what we're going to focus on, what our police are going to specifically identify, what the system is going to pursue as harsh crime. All right. So regardless, every element of the criminal justice system has three common objectives, and the textbook talks about this, and I do want to emphasize it. The three common objectives are efficiency, effectiveness, and fairness. And so ideally, I'd love if you actually knew these words before this class, but if not, that's okay. I am going to just make a text box instead of doing the typing thing, because I want to make sure that you can read this clearly. Efficiency, effectiveness, and fairness. And so these are the three common objectives of every element of the criminal justice system. Efficiency is that it economically applies available resources to accomplish all the goals, as well as improve public safety. It is done efficiently, so it's done cost effectively, in a timely manner, that kind of thing. You know, we're not waiting 45 weeks for one little thing. Effectiveness is carrying out activities with proper regard to equity, proportionality, constitutional protections, and public safety. Again, notice public safety keeps showing up. But effectiveness, this is that it is, we get into fairness, but it is also, it's equal. It is not like a murderer gets off completely scot-free. See O.J. Simpson. That's a whole nother issue. But the idea is that every part of the criminal justice system tries to be effective, or that it tries to make sure that everything is proportional and covered under constitutional law and is, in fact, for public safety. And then the fairness, as I've said, is ensuring equal treatment and equal weight to offenses in sentencing. Now, the text mentions this is treated the same through the procedure and process, not necessarily the outcome. So this is where people can get a little upset, especially with the courts. Sometimes the sentence and the punishment for an individual for a crime seems too little for a family that suffered a loss, and that's completely understandable. But at the same time, this idea of fairness, that it was equal treatment and equal weight for the offense in that sentencing. The process was done fairly. That's the best you kind of get with that. So fairness is kind of like, it has a little caveat. It's kind of it is fair, but it's not fair, so take it as you will. This is where we also get into the conversation of systemic racism and things that gets talked about a lot in modern times, to modern days right now. It is this fairness idea. Fairness is not fair. Fair is not equal. Equal is not equal. It's more or less the process was followed the same way for criminal A as criminal B and victim C. It was followed the same way, so therefore it's fair. This is why we teach this. This is why we hope that, as you go into these fields, you see the problems and you can see how to change them. I'm an academic. I'm not going to change it. Anyway, just to make sure, I've said it before in the first video, but I want to reemphasize, the Bill of Rights is the first 10 amendments of the Constitution. And remember, Constitution is the big thing. It's the key. Remember, Constitution is key to the criminal justice system. If you want to know if something's allowed or not, look to the Constitution. All right. So real quickly, I do want to talk a little bit, very briefly, about the juvenile court movement. Just because, again, this might be an essay question later, but I wanted to say the juvenile court movement began as a statute in Illinois in 1899 because the criminal justice system was treating any kind of juvenile over the age of 7, so 8 and up, they were tried as adults. And if you're thinking, oh my God, if you have a child that's 8 or older and you're like, they would be sent to prison like anyone else. Yeah. There was a whole thing. And so the idea of the juvenile court movement in Illinois was that children were not mini adults. They still were developing, so they weren't able to do that. And so they created a separate court system with different, I don't want to say punishments, but different sentencing. And so it was to avoid this kind of they're mini adults. It's more of they're still learning. So the focus in the juvenile system has always been treatment or rehabilitation. The focus in juvenile system has always been you're still growing, you're still learning, there's still a chance for you to move past this and become a better person. If only we could do that in the other systems. But that is the main focus of the juvenile system. If you take the juvenile justice class, you'll see that we continue talking about that more. But I at least wanted to put that here as a basis because pre-1899, yes, if you were 8 years old and you committed a crime, you were tried as an adult. All right, so I want to talk about crime a little bit. The chapter talks about it, and I do want to touch on this. Crime really is broken down based off of the seriousness of the offense and possible punishment. If you are a fan of cop shows or anything like that, you probably have heard the terms. If you are just doing this because you're like, I don't know, I guess I could do criminal justice, this might be the first time you're hearing these words. So either way, two of the main classifications are misdemeanors and felonies. And so misdemeanors are less serious crimes. They're usually punishable by a fine, maybe confinement in a local jail, but it's never more than a year. Like we're talking 6 months in jail and maybe like $3,200. Like that is a reasonable misdemeanor kind of thing. Felonies are the more serious. They're punished by fines, imprisonment exceeding a year, and in some cases, death. This is where the death penalty comes in. By all means, if you want to write a response essay on whether or not we need the death penalty, that is a possibility. We'll talk about that in a week or two. So, one thing I do want to talk about with misdemeanors, felonies are more widespread. Like we kind of agree on them across the board. Like murder is a felony in every state. But misdemeanors change depending on the state and depending on the circumstances. And so misdemeanors really, like I said, they depend on the jurisdiction to identify. So the local places. So what is a misdemeanor here in PA might not be a misdemeanor, might be a felony in New York State. And so things like petty theft, public intoxication, prostitution, simple assault, disorderly conduct, vandalism, all those things tend to be in the misdemeanor area. a good example is the decriminalization of marijuana here in Erie, within the Erie city limits. If you're caught with a certain amount of marijuana on you and you don't have a marijuana card, it is no longer a felony. It's no longer that level of crime. It's a misdemeanor. It's a citation, essentially, where you get a fine, and that's it, as long as it's under that legal amount. So that's where, it does change, because we're still dealing with marijuana legalization in other states. So this is a good example of how a misdemeanor can be more serious or less serious in different areas, different municipalities, different jurisdictions. It all changes. And so this is where you may or may not see this question, but can a crime be both a misdemeanor and a felony? Technically, they can be classified as it. It could just depends on the situation. So depends on jurisdiction. And the textbook offers one that I really like both of them. One is battery assault and the other one is arson. Technically speaking, I think we can all agree that arson is bad. You shouldn't set things on fire. But depending on the circumstances and where it is, if you burn down an empty building that's kind of small and it doesn't really do that much damage, that might be a misdemeanor. You might get 3 months in jail and a fine. But if you burn down a house and people are inside, that's also manslaughter, and so that makes it a more serious felony. So there is this weird sliding scale where sometimes a misdemeanor can also be a felony. Sometimes it depends on jurisdiction. So I want to just make it clear that I don't mean that the same exact crime can be both. I mean that depending on where it is and what exactly is all entailed, that can determine if a similar crime or the same type of crime can be both a misdemeanor and a felony. All right. So, and I kind of half teased this when I said a citation, but a violation of a law is really only punished with fines. You don't get jail time for it. This is, you commit a traffic violation. I said it in the last video. You get a ticket. You get a traffic ticket for making a violation of the law. That's it. You don't get jail time. You get jail time for not paying those tickets, because that's a whole different thing. So it's important to note the distinction between a misdemeanor, a felony, and a violation. Okay? That's an important basic thing that I'm sure we'll come back to again. But so on top of all this, and we're talking about crime, I do really briefly want to talk about crime statistics. So crime statistics do inform decisions typically made by individuals who make those decisions in the executive branch on what we focus on. So if, and this is just to explain how it works, if crime A goes down from a specific plan that you were using, then clearly that plan is working. But if crime goes up based off of that plan, it's not working. It's pretty basic, straightforward, but it's important to note that we do, I don't know why I say we, but in general, the criminal justice system uses these kinds of statistics and looks at where they go and how we can, what's most important and how to fix it. And so the textbook mentions a couple different ones, and I do briefly want to touch on the FBI's UCR, the Uniform Crime Reports. Most crime statistics do come from the UCR, but I do want to say that the link in the textbook has since moved, and so I actually did include it under the course-specific content. There is the FBI's UCR link. It is a new link that goes to their new page because they've updated, all the government sites have updated in the last couple years since this was the text was last updated. Anyway, the UCR program is really interesting. You can take a look at the report. So the latest releases are available, so you can actually look at the data because it's a different type of thing. It's under a whole bunch of other stuff. That's why it's not the same. But it's a really cool interactive map, and it's worth noting. We can look at Pennsylvania alone. So we can say, let's go to Pennsylvania. I want to see specific things. So we're Pennsylvania, the most recent year is 2020. Let's look pre-pandemic. Let's look at 2019 real quick. So in 2019, FBI estimated crime statistics for Pennsylvania are based on data received from 1,479 of the total 1,507 law enforcement agencies in the state. So most of them were reporting in. And so from 2009 to 2019, a 10-year trend of violent. This is all violent crime offenses. The big red line is the United States, and this blue part is us. Well, purple, but if we take away the United States, it's blue. So notice our overall violent crimes in PA went down, especially compared to the national average where it spiked back up in 2016. But we can sort this by so many different things. We can look at robbery alone. Look at that. It went down. I'll give you a hint. It continued going down in 2020. Arson goes down. Like, wow, what happened in 2014 where we were higher than the national average? Anyway, this is one of those things that if you're interested in crime statistics, the FBI's this UCR is really cool. I learned about it when I was in graduate school. This is one of those things that it's worth looking into if you like that kind of stuff. And this tells you, what kind of crime is currently an issue. The other thing that is brought up in the text is the NIBRS, NIBRS, which is the National Incident-Based Reporting System. I'm going to talk about that briefly. I'm going to keep on this page because I want to mention the whole reason this exists, the National Incident-Based Reporting System, is because the UCR does have flaws to it. So the UCR doesn't differentiate between crimes completed and crimes attempted. So someone attempted murder, it comes up as that. Someone attempted arson, it comes up as part of that statistic. Not they actually killed someone or they actually burned a building down. So that is one problem. The biggest issue is that it is only reported crimes. And so this dark figure of crime in the criminal justice system in particular is that a good portion of crimes go unreported. And we'll talk a little bit about that here in a minute. But so this was not catching all of the crimes. It only focused on the most serious crimes. It didn't count other ones, smaller ones. And there was no information demographic-wise on victim, offender, location, repeat, anything like that. So the UCR is good to watch larger trends, but it doesn't really give that much information. It's hard to predict any kind of patterns from just the UCR. And so this led to the National Incident-Based Reporting System. Still to this day, it has not been widely accepted across the entire United States, but it is still pretty well done. So right here they have this little blurb here. In 2021, the Historic Summary Reporting System data collection, which collected more limited information than the more robust NIBRS, was phased out. So NIBRS is now the main place for this kind of almost self-reporting kind of thing, and we'll talk about that here as well. So National Incident-Based Reporting System was to kind of combat this dark figure of crime. The U.S. Bureau of Justice developed the National Crime Victimization Survey in 1973, and what this was a chance for them to talk to the victims of crime. So robberies, rapes, murders, like the families of murder victims. Like this was a chance for people to talk about how that affected them, things like that. And so they got more information. And if you know anything about crime reporting and statistics, brief potential trigger warning, I do want to let people know I am going to talk about rape statistic information here. So if this is a sensitive subject for you, skip forward like a minute. So one of the crimes that has the biggest unreported number is rape. And that is because there's still a large amount of victim blaming within the system. So this is both for men and women. The statistics show that there are I think the textbook mentions half of rapes are go unreported. That number changes from year to year, but it might not be an exact half, but it is still a large number of these cases go unreported. And so this national incident based reporting system, this is a chance for some of those to go forward. They don't have to talk to a police officer and go through that trauma. They can simply talk about that this crime happened, and that gives us a more realistic statistic of how many are being attempted or completed. So, okay, excuse me. I just wanted to touch on that just so that we were understanding of NIBRS and the UCR. Obviously, there's a lot of sub things under the Uniform Crime Reporting. The FBI has a lot of really good information here that is publicly available. So if you're interested in these kind of statistics and stuff, please feel free to click on that. Like I said, it is a separate link. It is the FBI's UCR link right here under course specific content. All right, back to our notes. So because of this, and we have these trend datas and everything, and if you paid attention when we were looking at the different crimes that show up, there are index offenses. These are the more common, they tend to be major-ish crimes, and they're the most frequent crimes that are committed across the board. And so they have their own little grouping. And so this is, criminal homicide, forcible rape, robbery, aggravated assault, burglary, breaking or entering, larceny theft, motor vehicle theft, and arson. Please note, boat theft is not on here. Not everywhere has places with boats, so boat theft is not one of the big heavy hitters. So just wanted to emphasize that, these tend to be the big crimes. These are the ones that you can go pretty much anywhere, and they're all going to be felonies pretty much everywhere. All right. And I guess, actually, I do have the time to do this, so awesome. We are going to talk about the criminal justice process in this video as well, instead of doing a third video. And so this is kind of tying into the unreported amount of crimes is that dark figure of crime. The reality of the criminal justice process is until a crime is reported, it's not brought into this system. There's nothing that can be done. So until something is actually there, it's just not, it's not doable. And so that raises something a little bit sad with it. So let's talk about the actual process. And yes, I changed up the color because I want it to be known that we're talking about the process. So, as I kind of said, unless it's brought to the criminal justice system's attention, it goes unreported. Realistically, very few offenses are detected by officers performing random patrols. Again, that's not to say it doesn't happen, but it's not as common as, television makes it look. A lot of that is private citizens calling in and informing someone within the system. Sometimes it's calling 911, sometimes calling the police directly. It's letting someone know in the system that a crime has been committed. And so the process always begins from that initial reporting. So I guess I don't. I'm doing a text box. Sorry. So the process itself, like I said, I can even make it that color. Awesome. That makes my life so much nicer. Okay. So the first step in this whole process is that there's that initial reporting. And so, like I said, it's usually comes from private citizens, but it can come from a random patrol and things like that. So there is some kind of initial moment where we go, hey, something is going on. Once that crime is reported, we get to our first major thing, which is the investigation. And so the textbook really does have an entire chapter just on the process. I encourage you to read through it. It's really good. It goes through each of these step by step. Here we're going to talk about them kind of in that broader sense. So investigation, there's a couple different investigations, but typically the investigation process starts with a preliminary investigation. And that includes securing a crime scene, identifying victims, identifying perpetrators if they are there, identifying witnesses. This is all of the stuff that we don't see in most crime shows. This is the stuff that happens just off screen before the detective gets there. Sometimes the detectives are part of this in those shows, but trying to give a real world example that you might have seen to help you visualize what I'm talking about here. If there needs to be a follow-up investigation, that's when it just kind of keeps going. So the investigation stage is that first major stage after the report. It goes on as long as it needs, and this is where you kind of find out your information and things like that. It can be long because this is where you're gathering evidence. This is where, in a traditional crime show, 90% of the episode is step 2, the investigation. After that point, an arrest is made. So once the investigation is complete, the idea is that by that point you have enough evidence that is reasonable that the person could be found guilty. And so an arrest is made, and this is physical custody by a law enforcement. So you've probably heard the term citizen's arrest. This is where a private citizen physically takes a person into custody. But we're talking a traditional arrest is by a police officer or someone of the law enforcement. To be legal, you need probable cause. And I'm sure you've heard probable cause enough. I'm sure you've heard probable cause before, especially if you're going into criminal justice. You probably heard that term at some point where it's like, ooh. The idea behind probable cause is that you have enough evidence that a reasonable person could connect the evidence to the perpetrator. So this is where, planting evidence is an issue, but a reasonable person looks at all the circumstances, all the evidence, and goes, yes, they did this. That's what probable cause is. So during this arrest, and I mentioned it earlier, the big controversy in this is reasonable force to actually detain the individual and bring them into physical custody. We talked about it already, so I'm not going to talk about it anymore, but I just wanted to re-emphasize that this is where one of those big controversies in modern criminal justice system comes from, is in that arrest process. After an arrest has been completed, I feel weird saying completed. After an arrest has been, there's no good word. After that is booking. Booking is that actual official recording that the person has been arrested. This is the identifying part. This is the fingerprints, photographs, all that fun stuff for an individual. And I don't mean fun as in like it's actually fun, but the fun, sarcastic, these are the typical put them in booking, bring them in. This is the process of identifying who they are, what they did, all that stuff, putting it there, and it's officially in the system saying, yes, this is what they are arrested for. So this is the formal stage. This is something that needs to be done before anything can proceed. After the booking is the charging. And charging is where a law enforcement and prosecutors decide what crimes, if any, to pursue. If there's enough evidence to present, they will move forward to an actual, criminal trial or attempt to into that. So up until this point, the crime has been reported. The criminal justice system, the police, the whatever group is looking into this has investigated. They have made a formal arrest. They have booked it and put it on the records. And so now they're at the point of, okay, is there enough evidence? Please tell me there's enough evidence for us to pursue this case. That's where they charge the individual with the crime. This is where they hear it officially, not just from a police officer, but hey, this is going to be going into the system. And so that's where an initial appearance, and this is an initial appearance technically in court. It's not always like in the courtroom, things like that, but within the first 24 hours-ish of arrest, usually in realistic terms, not in Hollywood terms, usually the arrestee, the perpetrator, the whatever we're calling them, they will be seen by a judge or magistrate to have the charges read to them officially, as well as advised of their rights. And we're not the right to remain silent. We're talking like more than the Miranda rights. And to determine if enough evidence to actually hold the suspect. And so this is where bail is set at this point. If the judge or magistrate decides that there is a sufficient flight risk or something, they will keep them incarcerated in the jail until the actual court case can proceed. If they believe that they're not necessarily a huge flight risk, bail is set. And what bail is, and what people don't necessarily always understand, is bail is just, the monetary value, the amount of money that is to guarantee that you will appear in court. That's it. Bail is saying, hey, you don't have to stay in jail, but at this price, you have to show up on your day at your time, or then you're just going straight to jail. You don't get that trial at all. That kind of thing. All right. So after that is the preliminary. I want to make sure I was spelling it right, so I had to check my notes. Preliminary hearing and the grand jury. And I realize I'm going to now have to make this wider, and I'm okay with that. Okay, so the preliminary hearing, this is where the court determines if there is probable cause. And just to understand a little bit, the grand jury, how do I want to... I have not thought of how I want to explain this, so give me a minute. Okay, so I took a little break because I wanted to look up the best way to explain it. And so a grand jury is kind of like a regular jury, except it's done in the early phases of the process. They're not the same jury that, the traditional, they sit and they listen and they make decisions. The grand jury is part of this preliminary hearing. It's a group of individuals who listen to all the initial kind of evidence that's already been gathered and determines, is there a case here? And if they do, then it goes forward with a case. I don't know why I struggled with explaining it. Like I said, I was struggling, so I had to look up a better way to explain it. I had terminology, but not explanation. All right. So after this preliminary hearing, there's an arraignment, and it's a weird word to spell, so I wrote it down as well. So arraignment, this is where the defendant appears in court, has the formal charges read, and enters a plea. So this is, if you've watched crime shows or movies before and they go into a court and they appear before a judge and they read them their charges, and then they go, how do you plead? And they say guilty or not guilty, and then they go into an actual court case. That's this moment. That's the arraignment. The arraignment is where, you get the official, you are in front of the judge, you hear the claim, and then you get to choose, are you guilty or not guilty? So obviously, if you claim guilt, you can be sentenced at that moment by the judge, or depending on the judge and the jurisdiction, a sentencing might be later. You might simply have to wait. It all depends. They kind of change depending on where you are. But if you plead not guilty, this is where they schedule a trial. That's where they set a date and time that you will have to appear in court, and that will be your court case. So during this time, this is where pretrial detention or bail ends up coming in. So pretrial detention is when you're held in jail until the actual moment. Again, I mentioned it earlier. This is where, like, if you have a flight risk or something like that, or if you're a danger to the community. Bail, obviously, that's this, like I said, specified money, financial amount that ensures that you will show up in court on your day. Just so you know, bail is not a constitutional right. So how about that for interesting facts? This is also the time where plea bargaining comes in. Technically, it's like right before the arraignment, but it's part of the arraignment. Obviously, I mentioned it before, but plea bargaining is where the defendant accepts a guilty plea in order to lessen the sentence or some other aspect of it. And this is always done between the defendant and the prosecution, or the defense and the prosecution. It really, Hollywood likes to play it up, and no one ever takes it, but this is something that is very common in the real criminal justice system. So it's important to mention plea bargaining in a factual sense. All right. After that point, it should be pretty obvious, but the trial begins. And I shouldn't have to explain what a trial is, but in case you've never seen a trial or never heard of what a trial is, the whole purpose of a trial is to answer one basic question: the defendant's guilt. It must be based on facts and, accordingly, the jury's fact-finding. And so the important thing here, and I mentioned it earlier, it is the prosecutor's job. They have the burden of proof. It is their responsibility to provide enough evidence beyond a reasonable doubt that the defendant is guilty. That is their whole purpose. The prosecutor is always trying to prove the guilt. The defense is trying to prove innocence, naivety, whatever you want to go with. But prosecution is looking for proof of guilt. Defense is looking for innocence. It's an important thing I want to make sure that is clear, just so no one is like, I don't understand the difference between the two. Okay, so after a trial has been completed, there's always, of course, sentencing. And another one I shouldn't have to explain, but sentencing is where the official punishment is given out. Obviously, this is if the individual is found guilty. If they're not guilty, they're not sentenced. They're just let go. But if they are sentenced, this is where there are more steps in the process. Now, I'm going to call this 11A. This is appealing. Obviously, as I've said before, there's an appellate court, so you can appeal actual calls. What's interesting and important to note, the prosecution in a criminal case, so the city, the jurisdiction, the state, whatever it is, they cannot put forward an appeal. It can only be done by the defense. It's the whole reason if the party feels wronged, like the defense feels like, it wasn't fair and they truly should have been found innocent, they can bring it to a kind of a different court and have it reheard, but that is the appeals process. Like I said, it is primarily for the defense, not for the prosecution. Whoops, 11B, on the other hand, regardless of if the appeal goes, you know what? I don't like how I did that. I'm going to make that 11, make that 10A. That works better. Sorry. Because after the appeals, if you're still found guilty or it is put down or denied, it goes into the corrections phase. And this is where the whole point, as we said before, corrections is to protect the public and serve public interest. This is where we punish or rehabilitate criminal offenders. And this can be done through parole, probation, incarceration in a jail or prison, halfway house. Like, all of these things are part of the corrections. So after you've gone through the sentencing, after you go through the appeal, you go into the system. That's the corrections part. This is where it could be life, could be months, could be years, could be whatever. This is where you finish out your sentencing, is during the corrections. Now, important to note, in a rehabilitative, that's the word I want, rehabilitative system, the goal is to be able to release an individual afterwards. That you release them because they have been rehabilitated. With the punitive or punishing method, releasing means that they've done their time for the crime and now they can go back out into the world. So the whole thing is, no matter what, at the end of the day, unless you're getting the death penalty or life in prison, you get released from prison. You get released from the system. That's the end of the criminal justice system. Is it really? I want you to sit with that question. When someone is released from the criminal justice system, if they committed a crime and they went through all this and they got to release, are they really able to go back to a time before they were in the criminal justice system? There's a word that I'm going to use coming up in a little bit, not in this particular lesson, but pretty sure I'm spelling it right. If I'm not, I'll fix it later. Recidivism. This is the idea that once you commit a crime, you will recommit. The likelihood that you will recommit the same crime gets higher. This is a real thing that's going on. It's been going on for years. This is a psychology thing. This is a criminal justice thing. This is a social equality thing. This is a lot of things. And so we will talk about it a little bit, but I want to mention that that release isn't always positive. Sometimes it's just starting the cycle over again. So it's something to think about, something to talk about. I really just want you to really think about, can you go back after you go through the process? All right. The last thing that the text talks about, and I just really don't have anywhere else to put this, so the text compares the criminal justice system to a funnel. And I think the best way to explain that, it works. So the very broad part, committed. It's such a long word for me to write. Okay, so a crime is committed. The initial report goes in all the way down to conviction. Uh-oh. C-I-N-G. So from when the crime is committed and reported to the time that conviction has happened or sentencing has happened, the amount of crimes that see it to the end gets lower and lower and lower. And this is for a host of reasons. The textbook gives a couple reasons, but this is, court decides that treatment over incarceration. So the individual was mentally unstable, so they go to a mental facility rather than going to prison. Seems like a pretty good outcome, but that means that instead of going all the way through, they kind of stop at the trial point because sentencing gets into a other area. Sometimes that's decided in the preliminary hearing or the initial appearance that's going to happen, not actually get to trial. Sometimes police deal with a case informally and it doesn't go through this whole process. Sometimes a prosecutor decides during the actual charging, nope, that's not going to happen. This is the discretion. This is the everything. Things can change throughout that system, so it makes this funnel effect happen where we get lots of crimes, but not many that get to the very end. So that's the last thing that the text talks about, and that's really going to be the last thing I talk about here in our notes. So just want to say thank you very much for making it through. I know I talked about a lot of stuff, and I know it was definitely boring, so bear with me. Like I said, the textbook, I talked about in the first part how to get to the textbook. Please read through it if you haven't, at least chapter 1. And weekly folders. This is the other thing. I'm saying it even though it should be obvious. The videos, both part 1 and part 2, will be in this folder as well. This will not look the same. There will be another piece on it. Anyway, thank you very much, ladies and gentlemen. Thanks for sticking with it. If you made it this long, every question that's on the quiz has been answered in these videos. We talked about it. They're in the chapter. I kind of made emphasis on some of those points, so pay close attention. You'll do fine on the quiz. Anyway, that's it. That's all I got. Have a wonderful day, week, whatever time it is that you're watching these or doing this. I will be seeing you and talking to you soon. Bye for now.